Today's workshop is Students with Disabilities and School Discipline, Understanding Your Rights. I'm excited to introduce you to Cammie M Naylor, staff attorney with Disability Law Project at Vermont Legal Aid, Incorporated. She is a graduate of Clemson University, the University of Pennsylvania, and Vermont Law School. As a former children's therapist, Cammie has advocated for the needs of children and their families since long before joining Vermont Legal Aid as an attorney in 2017. She has a deep passion for protecting the rights of children and advocating within spaces where a child's needs and rights intersect. Thank you so much for joining us today.
Thank you so much for having me. I'm excited to be here to have this opportunity to talk to everyone and with everyone about students with disabilities and school discipline, to try to help folks understand what a child's rights are, and to hopefully give parents and advocates insight to what is expected or required, and a sense of a toolkit of what conversations to have when your child's facing discipline. First, thank you so much to VFN for graciously hosting this webinar. Again, as I said, this webinar is provided to try to prospectively address and answer many questions and issues we saw towards the end of last school year, especially as districts and schools are stretched incredibly thin by the staffing crisis. It's critical to have a shared understanding of what students' rights are as it pertains to exclusionary discipline. As a disclaimer, the information provided today is not legal advice. It is provided for the purposes of education and information. All right, so what are our objectives today? I hope to answer the following questions. Who can and can't be suspended? What is an informal removal? When the school calls to say they are sending my child home, what can I do? What is a manifestation determination review and when is it required? And when can a district change my child's placement and what are my options? You will see from the above, the greatest focus of today's discussion is on discipline situations that result in a child being removed from school and the due process rights available to the student once they've been removed. One discipline technique I will not address specifically is what we commonly refer to as detention. We do have a question later on about restraint and seclusion, but that is not the focus of today's discussion. So what is exclusionary discipline? Exclusionary discipline is any disciplinary action that results in a child being removed from school or having a different level of access to school that impacts their right to faith, which is a free and appropriate public education, which is the standard that's required under federal laws for students with disabilities to be able to access for education. So today we're going to really focus on the three major types of exclusionary discipline: informal removals, suspension, and expulsion. So we're going to start with informal removal. An informal removal is an action by the school that results in exclusion for part or all of a school day, and sometimes for an indefinite period of time. Here are some examples of informal removals: the school calling and asking a parent to come pick up their child, requiring a parent or guardian to not send or pick their child up early from a school-sponsored activity, shortened school day without an IEP or 504 meeting, or requiring a student to or excluding a student from a virtual learning environment. Schools do frequently call parents or guardians to inform them that their child is struggling or has had a difficult behavior. If a school is calling to inform a parent or a guardian of a behavior and that parent decides, I'm just going to come pick my kid up without being asked to do so, It's difficult to say that that's an informal removal because that was based on the parent's decision or action to say, I'm going to come get my kid. But that's not always the case. Oftentimes we find schools calling parents and saying, please come get your child. They're having difficult behaviors, or we've had a difficult day. They're struggling. We think they need to come home. So what are a parent's options when the school calls and says, please come get your kid? First, the parent should ask, is my child being suspended? If the answer is no, get more details about why the school is asking you to come and get your child. Depending on the circumstances, you as the parent can make the decision about how to respond. If you're being asked to come and get your child as part of a pattern or you're unavailable, it's completely reasonable to tell the school, I'm going to do my best to come. I'm not available. I'll be there at X time. It's also reasonable to say, I can't get there. They're in school. They need their services. We have found parents who have said, we just can't come. We can't come, send them home in the normal way, or we'll be there at the end of the school day. There can be difficulties for parents who choose that response, and schools, depending on the circumstances, we've seen referrals made to DCF in situations like that. Parents have the right to say, I can't be there right now, and this is what time I can get there. Section 504, which also covers students who are on IEPs eligible under the IDEA, requires that for these informal removals, the district provide the same due process requirements as formal disciplinary removals. What that means is that one thing, if this was a pattern that was happening for you, one thing that if you made a complaint to OCR, they're going to be looking at is, what does the documentation say? How is that documented? What does the call log or communication log look like? And so parents are strongly encouraged to, if you're facing situations like this, to make sure it's in writing, send a writing to the school district, highlighting what happened. I was called and asked to come get my child. I was told it was because of this behavior. And then if this is part of a pattern and you decide to complain to OCR, that documentation is there. And again, if this is happening, if you're facing informal removals with your child is entitled to the due process protections that we're going to talk about upcoming. Okay, so next we have suspension. We consider two types of suspension. A short-term suspension is any suspension that's fewer than 10 days. And a long-term suspension, which we think of as a significant change in educational placement, is any suspension that is 10 or more days. So what's a short-term suspension? As I said, that short-term suspension is any removal that's fewer than 10 days. For any short-term suspension for all students, the student, parents, and guardian are entitled to a notice, an opportunity to present their version of events. Prior to any removal, there needs to be a conversation that addresses the notice of charges, explanation of evidence against the student, provides an opportunity for the student or their parent to respond and tell their side of the story, and folks are entitled to a decision in writing. One of the most challenging pieces of short-term suspensions is that this hearing or conversation that parents are entitled to is extremely informal. What we see happen is school calls and says, this behavior happened, we're sending your child home, or suspending him for this many days. And that's all that happens. In large part, what we find is the reason that it happens that way is because families are not well informed on their rights to have a conversation about what happened. These are highly informal hearings. And so if you receive a phone call that says we're suspending your child for 10 or fewer days, 1 day, 2 days, they need to say, what exactly happened? How is that a violation of the student code of conduct? You need to understand their explanation. What is the district saying your child did? And have that opportunity to respond and say, you know, I hear you're saying that my child talked out of turn and that caused this dispute within the classroom that turned into, you know, an altercation or a verbal altercation. And you're telling me that my child needs to be suspended for 2 days. Are you aware that my child's ADHD causes them to have less control over when they speak? It's well documented. Here's what it says. How are you accommodating this in this discipline decision? For short terms, and then have that, you know, have that side, your side of the story, and get that decision about moving towards a suspension in writing. For these short-term suspensions, districts are allowed to, it's generally accepted that districts are allowed to remove students within the short-term suspension timeframe as students with disabilities as they would any other student. And like I said, this piece, this explanation is something that's really very often missed or really not even provided to families. And so if you receive that phone call that says we're sending your kid home, we're suspending them, I encourage you to say first, you know, tell me what happened, help me understand what happened, and take that information in. So this is short-term suspensions. Now we're going to move into long-term suspensions, and this is an area that you thought that was straightforward. This is that. So students with disabilities suspended for 10 or more days, either consecutively or adding up to 10 removals. That's considered a significant change in educational placement, and that student is entitled to a manifestation determination review. What's a manifestation determination review? A manifestation determination review is a process where the team, usually the IEP or 504 team, and often someone from school administration, meets to determine whether a student's behavior that caused them to receive exclusionary discipline was a manifestation of the student's disability. In the process of a manifestation determination review, the team needs to determine whether the behavior was a manifestation of the disability, and if yes, if the behavior was a manifestation of the disability, was the behavior a result of a school's failure to implement that child's IEP. In recent guidance, OCR shared the opinion or position that the manifestation determination review is an aspect of an evaluation. The reason that they got at this or addressed that specifically is that under Section 504, before any significant change in educational placement, 504 requires an evaluation. OCR said specifically in their guidance issued in July of 2022 that this manifestation determination review is a fundamental aspect of, in their opinion, that evaluation. For non-disabled students subject to long-term suspension, those students are entitled to a formal hearing before the school board. And we'll get into a little bit later on what that could potentially look like, but if you are a parent with a non-disabled student facing a long-term suspension, you're entitled to a formal hearing before the school board. So the team meets, they have this manifestation determination review, and the student is on a 504 plan. And the team determines that the behavior that resulted in the exclusionary discipline is not a manifestation of the child's disability. What happens? Under Section 504, so for a student on a 504 plan only, the district may discipline that student, the student with a disability, whose behavior was not a manifestation of their disability, as they would any other student. For students on 504 plans, if their behavior that resulted in exclusionary discipline is not a manifestation of their disability, they are not entitled to services unless, when students are facing long-term suspensions in that district, the district provides those services to all students. And this is a significant difference from students who are entitled to services under the IDEA. We're gonna pop over to the next side of the screen. So, student with a disability who is entitled, who receives an IEP, so they're qualified under the IDEA. They had a behavior that resulted in exclusionary discipline. They were suspended or reached their 10th day of suspension, and there was a manifestation determination review. The team agreed that the behavior was not a manifestation of the disability. In that case, the district may discipline that student as they would any other student. However, after the 10th suspension day, the district must provide that student services. So, biggest difference here, when there's no manifestation, students who are on 504 plans not necessarily entitled to services unless those services are provided to all other students. Students on an IEP, after a 10th suspension day, they are entitled to services. And those can be, the district is empowered to decide how or where those services are provided. We frequently see that showing up as tutoring for that child.
So Cammie, we do have a clarification question. So
Okay.
just for everyone, I will interrupt Cammie when it's clarification. Otherwise, I'll save the questions for the end. So the question is, do these rules apply to preschool or is it just K through 12?
Vermont law prohibits suspension for students up to the 3rd grade. However, that does not necessarily apply to students who are attending private preschool centers. So I think that that's a little bit more of a complex question and is pretty fact specific based on where that child is attending preschool. I would say that if a child is attending a preschool program at your public school, your child should not be suspended.
Oh, and just one additional, we are hosting a workshop next week on equitable and inclusive environments, stopping the suspension and expulsion of preschoolers in Vermont. So there will actually be a specific workshop on this topic next week. So
I
thank you,
expect the
Cammie.
person who's providing that workshop can answer that question far better than I can.
Yes.
If you have a preschooler who has been suspended and you have specific questions, there is information provided at the end of this presentation, and I believe in the chat, for how to get in touch with us. So you can do that too. So what happens? The manifestation determination team meets after the 10th suspension day or prior to the 10th suspension day. The 10th suspension day triggers the entitlement to a manifestation determination review. They meet and they answer the question, was this behavior a manifestation of the child's disability? They agree, yes, it was. If the team agrees, yes, the behavior that resulted in exclusionary discipline was a manifestation of the disability, the LEA, local education agency, must, or district school, must conduct a functional behavioral assessment, an FBA, unless there's a recent one. Recent is a difficult thing to define in these particular circumstances, because behavior is always changing and evolving. In a particular instance like this, if there's been a significant change in behavior that resulted in exclusionary discipline, I would generally say that whatever FBA you have is probably not recent anymore, and certainly isn't if it's an FBA from a year ago or something like that. So triggers the requirement for an FBA unless there's a recent one, and then requires an update of the behavior support or behavior intervention behavior improvement plan, and a return of that child to their educational placement unless the team, including the parent, guardian, or educational surrogate, agrees to a change in placement. So student is suspended for 10 days. On the 10th day, the team meets, they find manifestation. That student had an FBA that was completed 30 days ago and nothing has changed. This behavior was a known behavior. The team needs to be updating that behavior support, behavior improvement plan to better address the behavior. And then that child, and there should be no delay in doing that, and that child needs to be returned to school immediately, unless the parent and the team say, we really think that our kiddo needs a different setting. Okay. There are some exceptions if there's an immediate threat. So Vermont State Education Rule 4311 3.1 says, if a student is an immediate threat to him or herself, others, property, or educational environment, the district may take whatever action is appropriate under the circumstances, including but not limited to suspension pending a hearing as soon as possible. And it is preferred that for students with disabilities, that hearing takes place first. This is a more formal hearing, but not a hearing before the school board. So earlier when we were talking about short-term suspension, we talked about the informal hearing, that conversation. Why was my student suspended? What are the circumstances? An opportunity to respond and a decision in writing. If a child is what the district's considering an immediate threat for property, educational environment, or to him or herself, that phone call, informal meeting does not have to happen first. It still has to happen. It just doesn't have to happen first. And for a student with a disability, that meeting really should happen before the removal. An additional caveat to that is for a student who brings a weapon to school. Students with disabilities who bring a weapon to school remain entitled to all of the due process protections discussed above. However, they can be subject to expulsion. The rules require a hearing before expulsion. If a student brings a weapon to school, the school must refer them to law enforcement, and they cannot be expelled for more than 1 year unless certain other provisions of Vermont law are followed. So this is a circumstance where even if the behavior was a manifestation of the disability, the district is entitled and able to expel a student with a disability for disability-based behavior if it falls into this weapons category. For drugs and alcohol, recent OCR guidance explains that under the 504 FAPE requirement, that the 504 FAPE requirement does not apply to school discipline situations involving current use of illegal drugs or alcohol. This specific aspect of current use of illegal drugs or alcohol is not specifically addressed in the Vermont state education rules. And then there's an interim alternative placement. Oops, sorry. So a student with a disability can be removed to an interim alternative educational setting for not more than 45 days without regard for whether their behavior was a manifestation of disability if the child carries or possesses a weapon, knowingly possesses or uses illegal drugs or sells, solicits the sale of, or sells or solicits the sale of a controlled substance, or has inflicted serious bodily injury on another person. Serious bodily injury is not defined in the Vermont state education rules. Generally, a serious bodily injury is a bodily injury which involves a substantial risk of death, protracted or obvious disfigurement, protracted loss or impairment of a function of a bodily member, organ, or a mental faculty. And if any of those items, right, a weapon at school, knowingly possesses, uses, sales, or solicits drugs, or has inflicted serious bodily injury happens at school, on school premises, or at a school function, that child, regardless of their disability and whether that behavior was disability-based, can be removed to an interim alternative educational setting for up to 45 days, pending a determination of an appropriate placement. So expulsion, this is the last specific aspect of exclusionary discipline we'll discuss. Students with disabilities can be expelled, however, in general, not for disability-related behavior. Remember when we talked about the manifestation determination review? A student whose behavior was a manifestation of their disability is entitled to return to school with that updated functional behavioral assessment and behavior support plan. However, in the instance of weapons or extreme dangerousness, that student, regardless of disability, can face expulsion. Students facing expulsion are entitled to a formal hearing before the school board. By formal hearing, we're talking about an opportunity and a right to present evidence, to cross-examine the school or the district's witnesses, and to receive a decision in writing. This is a really formal administrative hearing. Students eligible for an IEP whose behavior is a manifestation of their disability remain entitled to services. Again, a student on a 504 plan whose behavior was not a manifestation of a disability does not necessarily remain entitled to those services. Sorry, I think I just messed that up. For a student on an IEP, whether or not their behavior is a manifestation of their disability, they are entitled to services. For a student on a 504 plan, even if their behavior is a manifestation of their disability, even when their when their behavior is a manifestation of their disability, they are entitled to ongoing services. If a student on a 504 plan is facing exclusionary discipline or expulsion, and their behavior is not a manifestation of their disability, they are only entitled to services if services are provided to all students. Sorry about that. So what is a change in educational placement? We discussed earlier that, being put out of school for 10 or more days is considered a significant change in educational placement. But how else can a student's placement change? So an IEP team meeting, the team can come together talking about the student's placement. They say, we really think your child needs a different environment or a more restrictive environment. Here's why. And the parent disagrees. If a parent disagrees with that decision and the team doesn't make consensus, the LEA, the person at the meeting who has authority on behalf of the district, is empowered to change a student's educational placement and issue a notice of decision. If a parent disagrees with that decision, they have a right to appeal. If the district changes a student's placement for disciplinary reasons for 10 or more days, or places the student in an interim alternative educational setting that the parent disagrees with, they are also entitled to appeal. And there's two types of appeals in these situations. We're talking about due process, and there's regular due process and expedited due process. And so if it's a discipline or behavior question, a child's entitled to an expedited due process hearing. Generally during while that hearing is pending, that child is removed to an interim educational placement. If a parent files for due process and they're not filing for expedited due process, you can invoke stay put, which requires the district to return the child to their previously agreed upon educational placement. And we do frequently see schools using a change in educational placement as in what families experience as a way to send their child to a different school. And so it's helpful to know that you have appeal rights in those situations and you are entitled to notice. So risk assessments are something that's coming up more and more in the last few years. A risk assessment is an assessment that is intended to determine a child's essentially dangerousness or their prospective potential for causing harm. In general, risk assessments were not developed for schools, and they're not, in our opinion, they're not a reliable way of measuring risk because an evaluator's decision and understanding of the circumstances is very subjective. However, districts are allowed to have risk assessments as part of their discipline procedures. The risk assessment for a student with a disability, the risk assessment process must not interfere with their right to FAPE. And so one example of that might be a district has a policy that if you are involved in physical altercation with someone else, you have to have a risk assessment. A student's approaching their 10th, before you can come back to school, a student's approaching their 10th day of suspension, there's a manifestation determination review that finds manifestation. That risk assessment needs to not interfere with that child's entitlement to return to school. So whether the district has to change the timing that they would usually provide that or let the child back into school before that happens, they can't interfere with that child's right to FAPE. So the district, again, must safeguard FAPE, and that includes coordinating with the student's 504 plan or IEP team. Again, we generally don't feel like risk assessments are a reliable resource in these contexts. However, you know, they are permitted. If you have a child facing a risk assessment and you have questions, you should definitely reach out to us. In recent OCR guidance, so OCR issued an updated guidance in July of 2022, they've strengthened the position of previous guidance from 2016 requiring positive behavior intervention supports. This guidance strongly advises districts to carefully implement proactive supports and services to address students' needs where their disability impacts their behavior, with the goal of avoiding a situation where discipline is warranted or considered, right? So I think we would all agree that this is something kids need, right? To avoid, for a student whose disability impacts their behavior, there should be a plan in place to avoid exclusionary discipline. And OCR has really strengthened their guidance on that to specifically provide districts with guidance and measures for how to ensure effective plans are put into place for students to avoid this kind of discipline. We don't want to see this happening. So can discipline be discriminatory? Discipline can be discriminatory if it's a denial of FAPE. So a failure to implement services, a failure to provide services, a failure to update services, right? So student is suspended for 10 or more days, there's a manifestation determination review, they decide they need to update the behavior support plan and it's not updated. And then the student's suspended again for the very same behavior. That's a failure to update the service or a failure to evaluate. So in that same situation, the district comes to realize, you know what, we don't really have enough information about why this behavior is happening, and they don't complete the FBA. And so the behavior support plan is not updated. Student engages in the very same behavior. That's also considered a denial of FAPE. So that is one way where discipline can be discriminatory. Also, depending on the circumstances, a certain pattern of discipline and not responding to behaviors, not updating the plan, that can be considered discriminatory. And before I go further, for all of these that we're talking about right now, whether discipline is discriminatory, the entity that a parent or guardian would file a complaint with is the U.S. Department of Education Office of Civil Rights. If you're going to make that statement that this is both a denial of FAPE and discriminatory treatment. You know, there is in education law, you have to exhaust administrative remedies. If you're just arguing a denial of FAPE, you can, of course, file a complaint with the Agency of Education through the state complaint system, the administrative complaint system. If you believe there's a denial of FAPE, you could exercise your right to a due process hearing. However, if you believe that the discipline is discriminatory, really the right entity to bring those concerns to is OCR. So another way that discipline can be discriminatory if it is a disparate or different treatment. So a discipline, policy, practice, or procedure that is applied differently to students with disabilities. And an example of that would be two students have a fight. One of the students has a disability and the other student does not. The student with a disability is, and this is from the OCR 2022 guidance, the student with a disability is suspended. The other student is just given a written warning. This could be disparate or different treatment. So then OCR would look at that and say, was the fight like an equal endeavor? Were they both equally engaged? If the answer is yes, then that is potentially different treatment. However, if the student with a disability started the fight, then the different treatment might not be discriminatory. It may be non-discriminatory. However, if a parent had filed a complaint with OCR on that instance, right? Two students engaged in a fight, very different discipline. And then the school came back and said, no, you don't understand. The student with a disability started the fight. OCR would say that's likely not discriminatory. However, they would continue with investigating the complaint to ensure that the reason given was the actual reason for different treatment. So for example, if they found that the teacher refers all students with disabilities that impact their behavior for suspension when engaging in an altercation, that could be a pretext for disability-based discrimination, even if that student had started the fight, but that teacher's philosophy would impact the finding of discrimination. Sorry, that was as clear as mud. So if you have clarifying questions on that one, I'm happy to take them. And then we have discriminatory effect. So take a school policy that prohibits swearing or profanity and has an accompanying disciplinary requirement like an automatic detention. That policy will be discriminatory in effect against the student whose Tourette's syndrome causes them to swear involuntarily. In this case, the school must reasonably modify the underlying policy to not discriminate against the student who swears. So what we have for discriminatory effect as a policy that looks like it's neutral, but then when implemented, impacts students with disabilities differently. And now I'm wondering if you folks have questions for me.
Well, thank you, Cammie.
Thank you.
I picked up the questions
Great.
that were put in the chat during your presentation, and we also have some questions that were asked before this workshop. So I'll go ahead and read them. So
I'm just gonna stop sharing my screen. So that we can
that
have
probably,
yeah, if I can figure out how to do that, because somehow I've forgotten. There we go. Okay, great.
Okay. So I think actually we'll start with a question about definition. You had mentioned stay put in one
Okay.
of your slides. So if you
Yes.
could just go over what stay put is and how a parent can access that or use it.
Yes, absolutely. So stay put is a provision within the IDEA, so in special education law, that requires when you file for due process and you invoke what's called, you invoke it as stay put, that child, despite whatever the dispute is about, is entitled to return to their previously agreed upon educational placement while the hearing is pending. And so stay put is a provision that triggers to return a child to their last agreed upon placement.
Okay, thank you. So this is a question I'm particularly curious about if and how harassment Title IX and harassment under HHB apply to adult to students' behavior where it intersects with disability discrimination. What are the lines between staff admin just violating plans, policies, FAPE, and where they enter into harassing behavior, 504 violations?
So I'm not sure that the asker of this question meant specifically to refer to Title IX, because Title IX is specifically for sexual harassment. So first, let's look at the definition of harassment. Harassment means an incident or incidences of verbal, written, visual, or physical conduct, including any incident conducted by electronic means, based on or motivated by a student or a student's family's members, or actual or perceived race, creed, color, national origin, marital status, disability, sex, sexual orientation, or gender identity that has the purpose or effect of objectively and substantially undermining and detracting from or interfering with a student's educational performance or access to school resources, or creating an objectively intimidating, hostile, or offensive educational environment. So I think first, unless a instructor, teacher, the adults are saying or doing something overtly offensive, we're probably not talking about, or not even overtly offensive, but saying something offensive that's disability based, we're probably not talking about harassment. That said, discipline is and can become disability-based discrimination. So again, if you're concerned that the district is using discipline to discriminate against your child, you might consider filing a complaint with the Office of the U.S. Department of Education Office of Civil Rights. They are the entity that investigates those types of complaints that merge between, FAPE and disability, and where is there a denial of FAPE, where is there disability-based discrimination.
Okay. Thanks. What would a parent do if they disagree with the manifestation determination decision made? Can they appeal that decision?
Yes, a parent can appeal a manifestation determination review decision. So they would be appealing a finding that their child's behavior was not a manifestation of their disability. It can be very difficult to prove a due process unless you have an expert who can testify on your child's behalf that behavior was a manifestation of their disability. But yes, that's appealable.
But only in a due process?
Yes.
Is that okay?
Right. That would be the only way to directly appeal. You could file an administrative complaint, but then you're arguing denial of FAPE, and that's not the method that's not the best method for getting your child to return to school, if that's what you're looking for. And if you're saying that the district's decision not to find this behavior and manifestation of my child's disability was discriminatory, then you might consider filing a complaint with OCR. But if there is a manifestation determination review decision that a parent disagrees with, that's notice, and they are entitled to take that to hearing if they wish to.
Okay, thanks, Cammie. I think this is a follow-up to the first question. What about a student meeting related to harassment of another student? Does FAPE or HHB trump?
Okay, I think what this asker is asking is, my child with a disability has been accused of hazing, harassment, and bullying. Can the fact that they have a disability prevent that from going forward if we know that whatever the hazing, harassment, or bullying behavior was is disability based? And the answer is no. There is nothing that's going to prevent that hazing, harassment, bullying event in investigation from going forward. And if a child, even disability-based behavior, even engaging in disability-based behavior, was meeting that definition of hazing, harassment, or bullying, the district's obligated to make an affirmative finding that that happened. However, in making that finding and determining responses to that finding, they are also obligated to ensure that that child is reasonably accommodated, that their FAPE is not impacted, that they continue to be provided services. And they're also required to protect the student who was hazed, harassed, or bullied. So that could look like a child with a disability being transferred classes so that they're not coming into contact with that other child, but also being provided some additional social emotional supports or SEL instruction to help them understand and work through that behavior.
Okay, thanks. The threat of referral to DCF can be scary for parents, and they may be reluctant to not pick up their child, especially if they don't know their rights. Do you know how DCF may be responding to such referrals? And I think another attendee did put a link into maybe some sort of study in the chat responding to that, but this is the question.
Yeah, that's really scary. I don't know how DCF is responding to those referrals. You know, that is one place that it can be very tricky. And, you know, I can't tell you the last time I saw one of those referrals happen, when a parent decided to put off the school and saying, you know what, I'll be there at 3 instead of I'm coming right now, it's 1:30, I'll be there in 10 minutes. You know, for a lot of parents, we live in Vermont. Vermont's a really rural state. I think the average commute time in Vermont is like 40 minutes. So even if you get a call at 1:40, you have to wrap up whatever you're doing at work or otherwise. And then, you know, so for a lot of parents, it's not unreasonable that they're not going to be able to be at school the moment or moments after they're called. And you know, again, your child has an entitlement. And if that happens, right, if you're referred to DCF for that, then that's part of why it's so important to clearly document what's been happening and send that documentation via letter or email to whomever at the school contact you, right? Like an email that says, I'm following up on our conversation today. You called me at this time to come and pick up my child. I asked you if my child was being suspended. You told me no. I asked you what had happened. You explained to me. We talked about how this is disability-based behavior. You told me we still need your child to go home. And that, you know, that conversation happens, documenting that, sending that back to the school administrator you spoke to, saying, you know, this is just a summary of the conversation we had today. Because if that repeatedly happens, if those informal removals repeatedly happen, that's denial of FAPE. Your child is entitled to the formal due process rights. And if that doesn't happen, if that's not being provided by the school, then you may want to consider a complaint to OCR.
Okay, thanks. Do the same due process laws apply for after-school program attendees on an IEP or Section 504? Can a child on an IEP be suspended from an after-school program separate from their regular school day because of behavior?
It depends. If a child, it depends on a number of factors, and it's not an easy question to answer. Most after-school programs are at school, so school sponsored, but often provided by like a local recreational program. Those programs in many cases have different funding sources, and there are ways to help with those funding sources. But if you have a child who is attending an after-school program and they really need a one-on-one, I would recommend first meeting with the IEP team and making a request for extended school day services to see if that child's paraprofessional or a different paraprofessional can be provided to them in the after-school program. In general, and this is not true in every case, we find that if it's a program that's not administered by the school, right, just school sponsored, not administered by the school, there is the 504 entitlement, access entitlement, and however, the local park and recs funding sources can easily claim, or do often easily claim, undue burden, right? It's too much money for us to provide a one-to-one for your child. And there are some resources for funding to try to overcome that, but they're not always reliable. So that's a really tricky circumstance. And if your child is facing suspension or expulsion from an after-school program, that would be a good time to contact us.
Okay. If a student is suspended, let's say a short-term suspension, and the school has not given information to the parents in writing, what is the parent's recourse?
I would start by asking for that. If you have documentation, you've requested that and you've not received it, then you could file a complaint with OCR. You are entitled to that. That's where I would start.
Okay. Do you know of resources regarding restorative practices that would be helpful to families, students, and schools?
Not specifically. I think the answer to this question really depends on what someone's looking for as a restorative practice. There is, of course, a push in the education community towards restorative practices and embedding those in schools to address individual behavior and peer conflict. If there's an ongoing dispute between a school and a family about a student's needs or their services, mediation through the Agency of Education, which is a free service that's provided through the AOE, can be a really good opportunity to discuss differences and concerns and hopefully find some common ground to move forward. That's not technically restorative practice, but it is an alternative dispute resolution technique. In 2018, the Agency of Education published a whole school restorative approach resource guide. Most schools that I'm aware of are implementing things like that. And because so much of education is centered on local control in Vermont, there's differences for how that's being applied throughout the state. So I would look regionally.
Okay, I think this is a follow-up to the last question. It says when there is a meeting pertaining to the suspension, part of the reasoning was the lack of staff to provide in-school suspension at the time. Should this be able to occur due to lack of staffing?
So an in-school suspension is still a suspension. It's still a school removal. So I think that begs the question, going back to what was the behavior? What was the removal for? Because ISS is still a removal. And so whether that's happening in school or out of school, you know, in sort of in my mind, in my analysis, that's neutral to the question of what was the suspension about? Was the behavior a manifestation of disability?
Okay, thank you. Let's see. That's would the rights of students and parents be the same if the children are not on IEPs or Section 504? So I realize this is the presentation of rights of students with disabilities, but I'm curious about my students that struggle with behavior but do not have IEPs.
So I think first, depending on what your student's behavior struggling behavior your student is experiencing, that might trigger the requirement to evaluate under the IDEA or under 504 to see if they're a student who might have a disability and would be entitled to supports and services and an offer of FAPE. So that's number one. Number two, as I said at the beginning of the presentation, for those short-term suspensions, all students are entitled to that interactive conversation, that very informal hearing. For long-term suspensions for students without disabilities, they're entitled to a formal hearing before the school board.
Okay, thank you. And we have a couple of minutes left. There was this question around laws and rights to protection when a child is restrained or secluded. So this was a question that came in before the presentation, and I just want to make, if the ask of that question is on this presentation, just to make you aware that we did have a workshop on this topic March 10th on restraints and seclusion, and this presentation that Cammie's given is not specifically around restraints and seclusions, but it's on our YouTube station, and it was March 10th. It was given by Tracy Harris, but I'm not sure though if Cammie did want to address that briefly.
Yeah, I can briefly respond to the question. The requirement under Rule 4500, the rule series that governs restraint and seclusion, is that a student must not be restrained or secluded unless they're an imminent danger to themselves or others. That rule also requires that students' individual circumstances and need to be taken into consideration when determining whether a restraint or seclusion is appropriate or going to happen at all. The U.S. Department of Education has published extensive guidance requiring use of positive behavior supports and discouraging restraint and seclusion. Right, the belief is that if a student's adequately supported, their behavior won't reach a place where they become an imminent danger to themselves or others. Under Rule 4500, seclusion is only available if for some reason restraint is contraindicated. Seclusion is seen under the rules as like the ultimate last resort.
Okay, thank you, Cammie. I think we've gone through the questions that came in before and during the presentation, but we have put Cammie's contact information in the chat, and certainly families are also welcome to call us at BFN. So thank you, Cammie, for this helpful information. You'll see the link to the evaluation in the chat, and we ask that you please complete this so we can make improvements and fulfill our grant requirements. We have many more interesting workshops coming up, and as I mentioned earlier, there is one specifically around stopping the suspension and expulsion of preschoolers in Vermont coming up next week. You can register for that on our website. We have links to all of our previously recorded webinars on our website. We have tons of information. Getting connected with us is easy. You can follow us on Facebook, join our closed Facebook page if you are a parent. We are here to help, and please contact us by phone or email, and you can also contact Cammie with that contact information that we put in the chat. So thank you everyone for attending, and have a great day.